And then I'm also going to enable the auto transcription in case anybody wants that. So, okay. All right, well, Ashley, whenever you want to get started, you are welcome to.
Absolutely. I figure, oh, hi, Joseph. I figure we'll give it a couple extra minutes. I always like to give everybody a second to come from court. I have the chat and the questions and the attendees on this screen over here for me, over here. So if I'm looking this way, you'll know that I'm looking at all the information that I have, because here is where my camera is. Hi, Nathan. Excellent. Yeah, I always try and run these webinars on like feeder time, so at least 5 minutes behind schedule so that we can make sure everybody gets in.
Sounds good.
This is where we would all be, shaking hands and catching up for a minute, and hopefully soon we'll be done with webinars and be able to have the lunch option matter again. So.
Right, we can give this spiel about, restrooms are over to the left. Lunch is going to come out in about 5 minutes,
If you'd like to go downstairs and get a beer ahead of time, please feel free,
Exactly.
Hopefully we can resume that in a couple months.
Right. Yeah. I guess before I get into my spiel, I'll just remind everyone that I am always interested in what people are looking for, what kind of events you'd like to see, if you have an MCLE you'd like to pitch. So often as we're working on something, we learn a new motion, a new fact, a new penal code section, etc. And then suddenly are like, how didn't I know this before? And if one of those comes up and you want to present it, please reach out. Even if you don't think it's a full MCLE, I can start assembling different bits and pieces. Or if you have an idea for a social event, I'm always interested in hearing what people want, what they think. If you want to get involved, we still have a spot on the board open, any number of options. Hi, Zuli. Joseph just posted in the chat. I'm also looking forward to this, Joseph.
I do appreciate it. Try not to let anyone down.
I'm sure you won't. I've seen the work you've put into this, and I'm very excited about it. Yeah, Dennis, excellent. We'll just give it one more minute in case anybody's still getting their final stuff ready. And then we'll start in. I hope everybody is excited about the Cal Shakes that's going to happen. I saw Anne put out a message. I love going to Cal Shakes with the Bar Association. Can't wait for that one. Excited to see it.
Yeah, and we've also scheduled an A's game now that the season is happening.
There we go.
In July, yeah, we'll do a tailgate party with excellent food, and we got really good seats. So check that out on the calendar as well.
Heck yeah, everybody take a look. Well, it's 12:05, so might as well get started. Hey everyone, I am Ashley Bargainquest. As you know, I am the president of the criminal law section of the Contra Costa County Bar Association and the host for today's event, What a Relief from Detention to Conviction and Beyond, that is being presented by Alan Kagawa. I wanted to remind everybody that we have some really cool upcoming events happening. Specifically, we have a two-part series that'll be happening on April 29th and May 6th, which is about human trafficking victim mitigation. It's actually being put on by a collaboration between defense and prosecutors, and I am really excited about that one. Like I said, it's a two-part, Friday back-to-back, April 29th, May 6th. Keep an eye out to look at that. It is really about making sure that we all serve that, pretty vulnerable community from both sides of the courtroom. And we are, I believe, going to be able to get a little bit of ethics credit on that, or at least some elimination of bias. So do keep an eye. But other than that, I would just like to introduce you all to Alan Kagawa. I am fortunate enough to work with Alan here at Tully and Weiss. He is an amazing criminal defense attorney where he works here at Tully and Weiss, fights for the rights of accused. Something you might not have known about Alan is that he was actually originally an emergency medical technician and studied law on his breaks from that job. After graduating magna cum laude from Whittier Law School, he joined Tully and Weiss and worked his way up from an intern to an associate attorney, where he is now fighting the good fight and working so hard. He has worked at post-conviction relief and getting it for clients, just years of doing so. And so he has made an easy-to-use, updated guide for us and our clients to be able to quickly identify avenues for relief and how to get there. And he is going to share and present that to us today. If you have any questions that come up, Alan has said that he is glad to answer those questions throughout this presentation. Put them in the chat or in the Q&A, and then I will pipe up, I'll turn my camera back on and ask those questions so that Alan can address them. Other than that, I hope that everybody enjoys this, and I will turn it over to Alan. Thank you, Alan.
Hey, thank you so much. So my general idea for this actually arose, I'd say about 8 years ago. I was actually back in law school. I was a law clerk for the public defender's office for 2 semesters and for the DA's office for about 2 semesters. And it's one of those things where, if you really stand out, really try to be ambitious, you get to have a lot more fun experiences. You get to end up doing a lot of, preliminary hearings, maybe even your own trials, something like that. I should have probably been more ambitious, but I figured, like, you know what, I'll do all the work no one else wants to do. I'll stand out. That is not a good way to stand out. But it did mean that I have done hundreds and hundreds and hundreds of post-conviction relief motions, and I've also opposed hundreds and hundreds and hundreds of post-conviction relief motions. Now, just a couple things before we get started. So I'd say the first thing is I'm actually going to be working with a bit of an agenda. And my general thought about this was, this is actually my first time teaching any sort of MCLE. And I know in many cases, people are quite familiar with certain areas, but maybe less familiar with others. And I understand this is lunch. And my general thought is, if I break it up like this, perhaps if you're quite familiar with obtaining client records and what to do in the event of a dismissal, diversion, or acquittal, but you want to focus more on collateral consequences, you can say eat your lunch during those sections and focus more on the others. And a big thing is I want to make sure you guys can enjoy your lunch. So all of these slides will be provided to you guys. I believe they're going to be sent out sometime next week, but I want to make them easily accessible. And I figure the last couple things are, I have done a lot of these, but there are certain areas where I don't have as much expertise. And when those pop up, I'm going to let you guys know ahead of time. In the event that I post anything that's incorrect or anything like that, please let me know. And when the slides come out, I intend to fix anything. Other than that, I figure thank you so much for coming here. I'll stop with introductions and let's get started. So welcome to What a Relief from Detention to Conviction and Beyond. My name is Alan Kagawa. I'm an associate at Tully and Weiss. The goal is to provide you with the tools you need to help clients who've suffered either an arrest or conviction clean up their records and fix related problems. And for those who are quite familiar with this, my hope is that I can provide you guys with a few additional tips so that you can save time. My general hope is, I know post-conviction relief is usually something that's just assigned to starting attorneys. And in many cases, people get quite good at that, but then they move on to other stuff. My hope is that I can go over some of the nitty-gritty details and make it so in the event that, say, you get a phone call from someone, a potential new client asking, hey, does SB 384 apply to me, anything like that, you can immediately let them know if that applies. And in many cases, if something does apply, you can immediately file something without having to do too much research or extra work, so that you can ideally make an easy $1,000 or so. Now, we're going to be focusing on 6 areas. Issues with client records, what to do if you have a situation in which an individual is arrested only, but no charging docket is provided, dismissals, diversions, and acquittals. I'm going to briefly touch on defective convictions because it's a rather significant area, and it pretty much deserves multiple classes of its own. What to do when you have what are known as standard convictions, which is a conviction in which there's not a clear defect and you're really just trying to get the conviction fixed without focusing so much on that defect. And finally, we're going to move to collateral consequences. What to do when someone calls and they say like, hey, I lost my firearm rights, I want them reinstated. I'd like to get off the 290 registry, stuff like that. Now, I'm not really going to cover defective convictions too much because there's a lot of motions you can file. And same with appeals and writs. These should pretty much be topics in and of themselves. And I'm also not going to cover very unusual circumstances. In particular, things like DNA exoneration, which is a very fascinating motion. But I don't think it'll be that helpful. And I've actually never filed it, so I'm reluctant to teach on that. Now, let's go to the first topic, which is client records. Now, sometimes you get an amazing client. You get someone who calls and they have everything archived. They have every document and you don't need to find anything. That's amazing. In most cases, though, that's not the case. So in many cases, you will have to go to the online case portal, depending upon the jurisdiction. I know Contra Costa County doesn't have one, but they're working on implementing one. In many cases, you'll need to go to the clerk's office and get the file, but in many cases, especially for older convictions, you'll find that it's destroyed pursuant to the government code, or it's archived and needs to be dug up, and the process often requires a couple weeks. In the event that records are simply unavailable or missing, a good idea is to obtain the client's rap sheet. Now, for Contra Costa County, we really don't need to focus on the first one, but there's essentially 2 rap sheets we're going to deal with. The first one is a local rap sheet, and this is actually more common in places like San Francisco. And the reason you want to request a local rap sheet is because in many cases, there's special court numbers on that particular rap sheet that are simply unavailable. And as a result, for example, I tried to file a motion to seal arrest from related records. It was actually rejected on the grounds that I hadn't obtained the local rap sheet. And as a result, I always make sure to do that when I file anything in San Francisco. For most cases, though, a Department of Justice rap sheet will suffice. And there's really 2 ways to go about this. Either an attorney can request it pursuant to Penal Code 11105, or the client can request it. And there's actually benefits to both methods. So in comparing the 2, for an attorney's request, the main benefit is you have a substantially faster turnaround. You really have 2 options here. There is a non-certified rap sheet and a certified rap sheet. The basic difference is that the certified rap sheet is supposed to be corrected and checked to make sure there aren't any errors, whereas a non-certified rap sheet is simply just a printout of everything they have. The one big advantage to a non-certified rap sheet is in most cases they are accurate. Not always, but in most cases they're accurate. What's really nice is if you put in the request, I've actually received documents back from the Department of Justice the same day. So for example, say you have a client and they call and it looks like they have an issue, but you want to get back to them as soon as possible. By sending this in the morning, there's a chance that by 3:00 p.m., you're going to receive a rap sheet from them. The certified rap sheet is especially good if you suspect that there's errors, though that one will often take 3 to 4 weeks. So it's a little bit slow. The benefit to doing it this way is there's no fee. Whereas if the client were to request everything, in that case, the client would have to pay a live scan fee, go to a live scan location, and the turnaround is often slower. Recently, clients have been reporting approximately 1 to 2 months. In some cases, I've seen them come back in about 4 weeks or so, 3 weeks. But in other circumstances, it's taken about 3 months. So it may be a bit of a wait. And often a big concern is if you have a client do that, by the time they receive it, they may not be interested in post-conviction relief. They may have moved on. They may be thinking about other things. However, there is one big benefit to a client requesting their own rap sheet, which is it actually allows clients to challenge errors. And from what I've seen, this is actually the only way to challenge an error on a rap sheet. Now, in order to request a rap sheet, the instructions are actually on the Attorney General's website. And essentially, there's two things you're going to need. You're going to notice on a couple of these slides going forward that I'm going to have basically box locations in the bottom. Those are going to generally refer to the forms you need. And my hope is that if you were to look at this PowerPoint later on, you could see basically you could just jump to that area, see exactly what forms you need, immediately Google those and print them off so that you can immediately take care of this without having to search and make sure you have all the forms. What's nice here is you can actually email everything to the Attorney General, and if you request a non-certified rap sheet, in most cases, they will just email it back to you. If you request a certified rap sheet, in most circumstances, they will mail it. And if the client requests a rap sheet, they will also mail that to the client. If you want to tell a client to request their own rap sheet, generally what I recommend is actually having them go to the Attorney General website. There's a nice little, basically just a breakdown of all the instructions. And basically they're going to want to print out one of those forms, fill it out, and basically just take it with them and pay the appropriate fees. Now, something you may notice is that the rap sheet may be wrong. A common thing is actually in the event of a motion, say, usually I see this with respect to motions to reduce felonies to misdemeanors. But in many cases, rather than actually modify the entry saying that, you know, this person has a felony and it's been reduced to a misdemeanor, actually create a brand new entry afterwards. And the big problem with that is in most cases, they don't modify the original entry. And to people reading the rap sheet, often this generates a large amount of confusion. And in many cases, they'll err on the side of caution and just assume that the person still has a felony. In order to correct this, what you'll want to do is have the client request their own rap sheet, and it'll include a form known as the BCIA 8706. Basically, what you're going to want to do is have them fill that out and mail it back to the Attorney General. In most cases, it's advised to have them include certified copies of the supporting forms. So the formal order that reduced the felony to a misdemeanor, the formal order granting post-conviction relief. But in general practice, I've actually been able to get away with just submitting normal paperwork from the court. And in most cases, actually, I've never actually had them rejected. One thing that's rather annoying is the process will often take 6 to 9 months. And oftentimes you'll get a call from the Department of Justice being like, yeah, we received this. And they'll let you know that it's under review or that they're processing it or that they intend to fix it. And in some cases, they'll even call you and say like, okay, this is what we're considering as the fix. Are you fine with that? That's great. Only downside is it will take a very long time. And recently, it's actually taken up to a year. So please keep that in mind. Now, let's move on to the second topic, which is what happens if you have a client who has an arrest and nothing else. So oftentimes this occurs in one of 3 scenarios. There's the beautiful situation in which a police officer or just, police department just decides to refuse the case. And that is absolutely amazing. Sometimes they do it just based on their own review. I find that rarely happens, but sometimes they do. Sometimes they'll also do it too if the person's merely intoxicated and nothing else. Seen that occasionally. One thing I see a bit more often though is if it's due to a mental health detention only. In many cases, they like a 5150 or something like that. Another situation that you'll commonly encounter is when the prosecutor has openly refused the case. And another situation you'll also find too is when the statute of limitations has expired. And sometimes these last two will be related. The prosecutor will just hold on to the case and say, hey, we're making no formal decision, but basically we likely won't file, but the statute of limitations still hasn't run. That's rather annoying. In that case, you could probably assume the third situation where you can just consider that the statute of limitations has expired. Now, in this case, you actually have 3 big tools available to you. The first one is a certificate of detention under Penal Code Section 849.5. The second is a motion to seal arrest and related records under Penal Code Section 851.91. And the last one is a motion for a factual finding of innocence under Penal Code Section 851.8. Now, there are benefits and downsides to all three. First one is the certificate of detention. And this guy's actually pretty darn amazing. What it does is it essentially reduces an arrest to detention, which really doesn't seem like much. But what's notable is in many cases, well, in certain cases, certain groups may ask for, if a client has been arrested. And what's great is in most cases, actually in nearly all cases, detentions do not need to be disclosed. And this is a great way for avoiding collateral consequences. What's great is that in many cases, if the police voluntarily choose not to proceed with the case, they're often automatically given. They'll usually just be like a single piece of paper signed by the arresting officer or another officer from the department. And if that's the case, that's great. However, it becomes a tad bit tricky when you start dealing with the final two situations where the prosecutor has refused the case or the statute of limitations has expired. In that case, you may need to do a bit of work. In particular, generally, if certificates of detention are not given, in many cases, you need to actually contact the arresting law enforcement agency. In most cases, I recommend doing that informally first. And if they don't get back to you, which is unfortunately rather common, it's a good idea to file a citizen's complaint. Those citizens' complaints are actually available on the law enforcement website. In particular, in your complaint, you want to include the following case law, which is Smith versus the California Highway Patrol. The reason this case is important is because this is a case in which an individual was arrested, but no charges were brought and no certificate of detention was issued. The reason this case is great is because the court not only found that this was inappropriate, but that attorney's fees were warranted. This case law is absolutely great, and a good practice tip I'd recommend is in many cases, it's a good idea to copy county counsel or the local city attorney. I find that when I do that, I often get very, very quick response. And I'd say the difference is there's a situation where I didn't do it and a situation where I did. When I did, I actually got a response the following day and also got a certificate of detention, two of them, the following day. Let's see. Now, a second option is a motion to seal arrest and related records under Penal Code Section 851.91. Basically, what this does is it seals arrests and related records in the event that, and basically it has two specific requirements. It requires either the statute of limitations has run or the prosecutor has filed a complaint, but no conviction occurred. And a big mistake I actually see here is a number of people like to immediately file a motion to seal arrest and related records as soon as the prosecution has refused a case. And like that in of itself is actually all right because it will hide records. But in many cases, what you actually want to do here is you actually want to file, you want to obtain a certificate of detention, just because the certificate of detention is substantially better. A motion to seal arrest and related records in and of itself does seal the arrest and related records, but these arrests may be pleaded and proven in later prosecution, which isn't the case if you get a certificate of detention. And it still must be disclosed if the person's applying to be an officer, they want to run for public office, for licensure, or to contract with the California State Lottery Commission. Oftentimes, especially when you're dealing with people who later want to be a police officer, it's actually quite bad to not seek a certificate of detention when that's available. What is notable, though, is from my experience, the court actually will grant a motion to seal arrest and related records, even if the technical requirements of the statute of limitations running or basically if the technical requirements aren't met. And I believe, if I were to suspect, that this is mainly because, the court receives so many of these and they just assume that everything is met. And from what I've seen, there's no harm in filing it. Just please make sure to also obtain a certificate of detention as well. Now, the third option is to obtain what's known as a factual finding of innocence under Penal Code Section 851.8. And these are pretty great. Not only does it steal the records, but it also, after 3 years, is followed by the destruction of these records. Now, this sounds absolutely great, but what's very, very difficult is that generally, in order to get one of these, it has to be shown that no reasonable cause exists to believe the petitioner committed the offense. And that is going to be pretty darn tricky, because in many cases, that amounts to the law enforcement agency admitting that they messed up really, really badly. If you're able to obtain one of these, this is absolutely great. But in practice, in most situations, I imagine you'll likely be going for a certificate of detention or a petition to seal arrest and related records. It should be noted that the main case authority with respect to motions for factual finding of innocence are usually with respect to cases where it's absolutely clear that the person was innocent. So it'd be something like, you have like a doctor who was convicted of practicing without a medical license, but it turns out that the entire time he actually had a medical license. Now let's move on to the third topic, which is dismissals, diversions, and acquittals. Basically, if you got one of these three, you're doing an awesome job as an attorney. With respect to dismissals, there's really two things you could do. The first is just a motion to seal arrest and related records under 851.91, but the second is a motion for factual finding of innocence. And in many cases, if you think you can potentially succeed on a factual finding of innocence, it's recommended that you go for that first. And in the event that that's unsuccessful, you go for a motion to seal. It's a nice backup, and in many cases, clients are entitled to the motion to seal as a matter of law. There's just a couple exceptions, which is often if they have a pattern of some sort of abuse. Patterns usually it's considered to be a pattern if the person has 2 prior convictions in that field, or they have 5 arrests in that field. So in most cases, that will not be met. And even if that is met, you could still argue that's in the interest of justice for this relief to be granted. And if they meet it through a different technicality, in most cases, what's nice is the client's actually entitled to a motion to seal arrest and related records as a matter of law. And I do need to back up real fast because the 2 appropriate forms you're going to need are the CR 409, CR 410, which is the order and the proposed order. With respect to diversions, in that case, in many cases, it's going to be incredibly hard to get a factual finding of innocence because in many cases, by accepting the diversion, it's sort of assumed that the client is basically that there may be some potential truth to the allegations or some evidence that may potentially support it, and it'd be extremely difficult to get a factual finding of innocence. In that case, usually the proper method is a motion to seal, and there's actually special statutes such as Penal Code Section 851.87 that actually guarantee this relief at the completion of diversion. When it comes to acquittals, it's similar to dismissal. You can either file a motion to seal or a motion for a factual finding of innocence. In many cases, recommended if you think you can win on it, to file the motion for a factual finding of innocence first, followed by the motion to seal if that is unsuccessful. Now, I'm going to briefly touch on defective convictions just to mention that there's a lot of material here. You're going to have a lot of complex post-trial motions, a number of things that basically when you're in a sentencing hearing, the judge asks if there's any legal cause as to why sentencing should not be pronounced. A lot of these motions would apply here where you'd say, actually, yes, and then you go over that kind of stuff. With respect to defective convictions, there's also appeals and writs. I have some experience with this, but since this is not my main area of expertise, your best bet is actually probably to get a guidebook like Levinson on criminal procedure to specifically go through these, because these are incredibly complex and you're going to want a very specific guide with respect to the specific type of motion you want to file. Rather than that, I just want to move ahead to basically what I'm going to refer to as standard convictions. And these are convictions where there may have been something defective, but we're not focusing on that. We're treating the conviction as if, it's more or less formal and how we should go about addressing that. So I'm essentially going to break this down into a number of sections. We're going to go through expungements under the Penal Code Section 1203.4 series, early termination probation, nunc pro tunc motions, reductions from felonies to misdemeanors, certificates of rehabilitation, governor's pardons. I'm going to briefly touch on cannabis convictions. We're going to briefly go over Prop 47 convictions, which are only going to basically, the relief for that has to be done by this upcoming November. And in most cases, those have already been taken care of. And I do want to briefly go over some of the new Senate bills, because I imagine you may be receiving a number of calls from your clients about whether or not certain things like the 1-year mandatory prison prior enhancement still stands. So with respect to expungements, these are basically, this is your standard way of helping fix someone's record. And they're all right, but they're not particularly great. Basically what happens is you withdraw the guilty or no contest plea, and then the court formally dismisses the action, which sounds amazing initially. And it seems good because in many cases it's helpful for clients who want to later get a job. Generally looks better if someone's been expunged. It's supposed to be easier to help a client obtain a license, but I don't personally find it that helpful. It can help with immigration consequences, and it's generally a piece of paper that says, hey, you know, this person has basically stayed out of trouble, they're all right, but they had this in the past. What's bad is this isn't a true expungement. It doesn't remove this from their record. It doesn't remove the consequences of a conviction in most cases. It's only applicable to certain convictions, in particular many felonies, such as felonies where, you know, people are facing life, or the 290 series of felonies, so sex offenses are ineligible for this kind of relief. Even if something's expunged, it can still be used as a prior offense. And the big thing is it does not restore many rights, including firearm rights. It's all right, but it's a bit problematic. Now, the big things are, in most cases, and most, I'll get to some of the exceptions, clients must have completed probation, and in general, they have to be not currently facing any new charges or punishment for some sort of new offense. And what is notable here is you're probably going to end up filing a bunch of these. And since you're going to be filing a bunch of these, one thing to note is that in addition to the standard expungement form, the CR 180 and the proposed order, which is the CR 181, you're absolutely going to want to include a declaration under MC 031, an attached declaration, if you're dealing with something special. And these aren't just like your non-standard convictions. This is also for stuff too, like any sort of violation of the vehicle code. In most cases, you have to show additional reasons as to why this relief should be granted in the interest of justice. And a common mistake for many attorneys is to file an expungement for a DUI and then have it rejected on the grounds that there weren't any additional grounds given. These forms do have a special area where you can mention why it's in the interest of justice, but in most cases, I would advise just including a separate declaration in that you can make reference to any number of character letters or anything like that. And in many cases, probation will not oppose if you have something like that. I should also briefly mention too that the turnaround time on these, it's rather, at least in Contra Costa County, is rather strange. So if you just submit something, and in many cases, it's a case where the individual's just completed probation, nothing too fancy. I've actually had them, I've received them anywhere from, I'd say, like a couple of weeks after I filed them to it's potentially maybe about 6 months. Recently, I've actually had a number of mine where I filed them during the pandemic, and I actually didn't receive them until approximately a year and like a couple months after. So please let your clients know that there may be a slight delay involved in some of these. Now, one thing I do need to mention is there's actually a brand new law. It's Penal Code Section 1203.425, and it's actually a pretty great law. Not great in terms of earning money, because what it does is, for many cases for arrests, non-convictions and convictions occurring on or after January 1st, 2021, a relief will be automatically granted. Now, there are a lot of exceptions, and especially in the cases of felonies and stuff like that, there's a good chance it may not be granted. However, it may be worthwhile to investigate whether or not this relief has been granted to one of your clients just before you file. Supposedly, this is supposed to start taking effect on or about July 1st of 2022. And this actually may be a situation where it might make sense to request a non-certified rap sheet just to quickly just take a look to see if this relief has already been granted. So you're not charging your client for extra work that's not necessary. A rather related motion is a motion to terminate probation. And what's kind of nice about this is in many cases, if you file this and it's granted, there's a chance that the court may also grant an expungement as well. These are generally granted when the individual is performing well in probation and is pretty close to termination. In many cases, if they've completed all their requirements, it's generally advised to also file for an expungement, especially if it looks like the district attorney may be on board as well. A less common motion is a motion for nunc-pro-tunc relief. And if you're filing one of these, it generally means that you did a pretty good job negotiating. Basically, what nunc-pro-tunc relief is essentially that the court will go back and essentially delete a conviction. And in many cases, but not all cases, we'll get rid of the consequences of this conviction. You do need to be especially tricky, though, when it comes to things like the 290 registry, because those requirements may not necessarily come off. And you want to make sure that if you're ever entering any sort of plea that involves a nunc-pro-tunc resolution, that you explicitly include on the record what the specific terms are, just so that you're not facing something else later. But basically, this is generally a written motion and usually requires a pre-existing agreement, plea agreement with the prosecution that's been accepted by the court that says if an individual is fully complied, usually a charge will be completely dismissed. In many cases, it would be a plea to say like a felony and a misdemeanor, and upon successful completion of the entirety of probation, the prosecution agreed not to oppose a nunc-pro-tunc motion, forgive me, in many cases, agrees to nunc-pro-tunc relief. Generally, the court won't automatically grant these, so you will need to file them. Now, a big one is basically a motion to reduce a felony to a misdemeanor. In many cases, you'll want to file these if, say, you get a call from someone who wants their firearm rights restored. What's great about this is if this is granted, the client can honestly say that they're never convicted of any sort of felony. In many cases, it actually does. It's supposed to make it easier to obtain licenses, but in many cases, licensing agencies are really picky, so it may not necessarily happen. But I'd say one of the big things is if this is the only thing preventing these rights, it will restore both firearm and jury rights, which is absolutely amazing. In order to file this, just to be eligible for this kind of relief, there's two big things. First is that basically the accused has to have been convicted of a wobbler, and they must have been sentenced to and completed probation. I did not include this on the slide, but there's a very significant distinction between imposition of sentence suspended and execution of sentence suspended. In the event that a client receives an imposition of sentence suspended, they're still eligible to apply for a 17B motion. However, if it's execution of sentence suspended, in that case, even if the individual did not do any prison time, they will be statutorily barred from receiving this kind of relief. Now, a rather unusual situation, but one you may come across, is if an individual has received an expungement. However, when filing that motion for an expungement, they also requested a 17B motion, which was denied. In that case, so long as the individual has still lost a number of rights, under Meyer v. Superior Court in and for the County of Sacramento County, an individual can actually still proceed with a 17B motion, even if 1203.4 expungement relief has been granted. And a reading of this case does suggest that this case will also apply in basically any situation in which a person's rights are still lost. In many cases, you may find this in juvenile court cases where an individual has lost a number of rights under very old statutes, and it looks like they've received relief. However, based upon the new statutes that have been created, due to technicality, they are still missing their firearm rights. So I use this case a lot. I would consider using that if you have a situation like this. I'd say what's nice is the forms here, the CR 180 and CR 181 that's used for expungement also give you the option of including a request for a 17B motion, which is very great. The big thing though is in many cases, you may have a situation in which the facts don't look entirely good, in which case I'd actually consider writing your own motion in which you go into detail about the alleged facts and explain why, it's they misrepresent the client's situation or just the client's incredible rehabilitation afterwards. Now, on to certificates of rehabilitation. Certificates of rehabilitation are generally what you seek if the individual is not eligible for an expungement. They have certain benefits, but they aren't entirely great. So it serves as a general proof of rehabilitation, or at least it's supposed to. It does look better than not having it. If a client obtains one of these, the state licensing agency is not supposed to deny a license solely based upon a rehabilitative conviction. But by the time an individual is able to petition for this, they probably haven't been able to get their license for a very long time. And in some cases, it can remove the 290 registration requirements for less serious 290 cases. But due to a new Senate bill that has passed, there's actually a better way you may want to consider doing this. That might be a whole lot easier. There's a lot of technical requirements here. The big ones are that they have to serve a period of rehabilitation, which is usually 5 years of residence in California, plus additional time depending upon the conviction, which could be 5 years, 4 years, or 2 years. They want generally what the court's looking for is no subsequent incarceration, but what this really comes down to is no new convictions. What's nice about a certificate of rehabilitation is that it actually automatically, if it's granted, it actually gets sent up to the governor as a request for a governor's pardon. There are two big routes to request a governor's pardon. You can either file a certificate of rehabilitation, or if you want to, you could directly request the relief from the governor. In most cases, it's recommended to file a certificate of rehabilitation, except like in very rare circumstances where an individual doesn't qualify due to a subsequent conviction, in which case their only route may be a governor's pardon. However, if they have that subsequent conviction, there's a very good chance that they will not receive a governor's pardon. The chance of receiving a governor's pardon is unfortunately rather low. If you're able to do it, you're an absolutely amazing attorney. It results in the restoration of firearm rights, asterisk, unless two big things have occurred. Either there's a domestic violence conviction and the individual is barred because of basically there's a federal law that prevents individuals who've been convicted of misdemeanor domestic violence crimes from ever possessing firearms, or pursuant to California law, they allegedly possessed a dangerous weapon for the underlying conviction. You want to take a look at exactly what rights, but in general, it restores most rights. It also, in most cases, grants relief from 290 registration, and in many cases, it's incredibly helpful for immigration relief. In the few situations in which I've seen this be granted, oftentimes they're immigration situations in which the individual absolutely needed this governor's pardon. If that is one of your situations, you have a person who absolutely needs this, who's not a U.S. citizen, you may want to strongly consider seeking a governor's pardon because those are currently being granted, though they're still quite difficult. Now, in the event that you are able to get a governor's pardon, first of all, absolutely congratulations, that's amazing. Follow it up with a motion to seal arrest and related records. The governor's pardon doesn't seal these records, so by doing this, you could potentially hide them. Let's see. And I also should mention too that when it comes to these forms, generally when it comes to certificates of rehabilitation, at least my experience with this has been in Orange County. But from what I've seen, generally you're going to want to seek a local form that's available with the courts. I don't believe there's a standard form available. And if an individual does want to directly apply for a pardon, they can seek that application from the government's website. Though I do strongly recommend going the certificate of rehabilitation route, if at all possible. Now, one thing to note is, say you have some sort of cannabis conviction, and it's from prior to November 9th, 2016. As you probably know, a lot of these convictions have actually been reduced to basically things that are legal, lesser offenses like infractions or misdemeanors, or in some cases, wobblers. In particular, if you see any sort of health and safety code violation for possession, cultivation, possession for sale, or unlawful transport, please take a look at this, because your client may actually no longer be guilty of a felony or a misdemeanor. Or in some cases, they actually may be guilty of a wobbler, which is still quite good, because in certain situations, the fact that, maybe it's just reduced to a wobbler is great, because it means that individual may be eligible for 17B relief and may actually be able to clean their record. Now, one thing I noted, because I actually filed one of these when probation had been transferred, is you do need to file this in the court of the original jurisdiction, even if probation has been transferred. So this actually meant me having to file at the Harbor Justice Center in Orange County, which is a very long drive, but thankfully, because of COVID, they accepted filing by email. Another thing to note, though, is you may actually want to take a look at your client's rap sheet, because what's great, and I mean, not great for business, but what's great in terms of justice and fairness is that many courts have actually been automatically cleaning up these cannabis-related arrests and convictions. So I would take a look before you file these documents. The appropriate forms are the CR 400 and CR 401. And I do believe there are two following, I think the CR 402 and 403 that are with respect to juvenile convictions. Now, I do want to briefly touch upon Prop 47. And the reason for that is because the deadline in order to get certain felonies recalled or redesignated as misdemeanors under the section is actually November 4th, 2022. So if you see these situations, you should immediately file something. In particular, this is going to apply to certain drug offenses, especially simple drug possession, but many offenses regarding any sort of theft under a certain dollar amount. And there's actually a really relevant case that just came out recently, and that's People v. Grant. Now, as you guys know, when it comes to calculating dollar values with respect to whether or not something should be considered a felony or a misdemeanor, generally what case law has said is that it depends upon the fair market value. And, that's great. But the thing is, say you go to Macy's and, or some sort of store where things are just constantly on sale all the time. In those cases, you can go through the store and you realize that basically the MSRP price, basically the manufacturer suggested retail price that's on every one of the tags, isn't the true value of the item. The true value of the item is actually closer to the sale price, given that the item is almost always constantly on sale, or is very likely to be constantly on sale, at least most of the time. What's great is that this case actually involved a store where everything was discounted. An individual was arrested, but in terms of the price that was used, they used basically the MSRP or sticker price rather than the actual cost of things. And this case law says that's completely inappropriate. Basically, the fair market value should be an amount of, should be the amount people are actually paying. So if you do get these situations, absolutely cite that case. Here, generally, you're going to want to check. Some jurisdictions have local forms, but in most cases, you're just going to want to do a written motion. Now, you may have heard of a couple of new Senate bills, in particular, Senate Bills 136, 483. Basically, these new Senate bills that have modified things for people who are currently in prison. And there's a couple, but there's one in particular I want to focus on, and that's the first one, which is under Senate Bill 136 and 483, which is the 1-year prison prior. And basically, what this new Senate bill that just came into effect actually this January, what it says is that if you have an individual who has a 1-year prison prior, these 1-year prison priors are actually, they're actually no longer legal. And any individual who has these has to get them removed. There are going to be a couple other Senate bills that you may have people call, hoping that the thing might apply. You got under 1393, the 5-year prior strike removal, that the court has discretion to potentially remove this. Unfortunately, this only applies to non-final cases. The firearm use enhancement, discretion to strike under 620, which also applies to non-final cases, and SB 81, which is potential dismissal of certain enhancements. Unfortunately, in that case, sentencing must occur after January 1st, 2022. Now, the one that you're going to see, and if you get these calls, that's absolutely great for them, is this first one, the 1-year prison bar. And the big exception is if you have some sort of sexual offense. In particular, I think in most cases, sexually violent offense, but check regardless if it's any sort of sexual offense. But what's nice about this is I actually filed a petition for this. And what I learned from filing the petition is the public defender is actually currently working on this in Contra Costa County as well as some other areas. In most cases, you actually want to probably check with the local public defender's office just to see if these motions are already in progress. What's supposed to happen is that according to the statute, the government has to identify individuals who qualify for this kind of relief by March 1st in the event that they are just merely serving time as a result of this enhancement, or July 1st, basically if the individual is just serving a base term or time from a different enhancement. And the thing is that relief must be granted by October 1st, 2022 for individuals who completed their base term and are serving a sentence based upon this, just this type of enhancement, and December 31st, 2023 for all under individuals. I'd say if you have a situation in which an individual qualifies for this and they are just serving time based upon this, you may want to consider filing a motion. But otherwise, a lot of this relief is being automatically done. So you may not have to do anything, and you may want to check with the local public defender's office. All right, so collateral consequences. I'm going to be covering a couple things here, which is basically the things I most often get when someone calls me, which are firearms, the sex offender registry, licensing, concealed carry permits, which I typed twice, delete that in the version I give to you guys, TWIC cards, civil restraining orders, and return of property. In particular, general returns of property and firearms as well, just because there's a very annoying extra restriction. So with firearms, it's going to be critical to identify the method in which they were lost. What you really are hoping for is that in many cases, it was lost just because the individual has one felony, they didn't do any prison time, they're eligible for 17B. That is what you hope for. There's a couple big things you want to watch out for, which is an individual may have a firearm ban as a result of some sort of restraining order. They could have a firearm ban as a result of domestic violence on a federal level, in which case even a misdemeanor for domestic violence renders an individual ineligible to possess a firearm. You also want to check too, if you're going the governor's pardon route, to see if a dangerous weapon was involved, because in that case, even the governor's pardon won't restore this right. For a single felony, in many cases, what you want to consider is either a 17B or a governor's pardon. Given the unlikelihood of a governor's pardon, in most cases, you hope that they have 17, they're eligible for 17B relief. Now, with respect to sex offender registry, it's actually really exciting because of SB 384 and PC 290.5, there's actually a great way to get people off the sexual offender registry. Essentially, there's 3 tiers, kind of below them. So essentially, there's the first tier, which is 10 years of actual registration. And that's basically for low-level sex offenses, or if some sort of offense involves a sexual component, something like that. There's tier 2, which is for like the 288, it's like a lewd act against a minor, stuff like that, without additional aggravating factors. In many cases, that's 20 years, though there's really just a sub-tier of tier 2. And that is an individual will actually only need to serve 10 years of actual registration if they were under the age of 21 and basically that the alleged victim was close in age. I think it was about 14 to 17, and there was no violence or anything like that. And tier 3 is basically lifetime registration. And one thing you'll really want to make sure that you avoid is, in many cases, you may see an enhancement, especially if you're dealing with a lot of sexual offense cases, for Penal Code Section 667.61, which is the multiple, in many cases, I think it's subsection like E4, something like that, is the multiple victim enhancement. And this actually confers life even if the underlying offenses do not constitute a lifetime registration. Now, there's a couple things you want to note. You'll probably get calls from a number of individuals who, their conviction was 20 years ago, they're on the 20-year registry and they want to get off, they just received a letter. The big thing is they actually have to formally register for 20 years. Just the fact that they got off the conviction, well, they were convicted 20 years is not enough. And what's notable too is in the event there are any sort of new alleged offenses that may actually stall the amount of time. So that time will need to be added on. However, if you do have an individual who looks like they are formally eligible for this kind of relief, what you're going to want to do is file this on or after the client's next birthday, after July 1st of last year. And what you're going to want to have them specifically request is proof of current registration, because any sort of application will require that. There's actually a great form for this. It's the CR 415 form. It's really easy to fill out. It's going to include proof of current registration, and you can have an individual moved from the registry. Now, one thing you do want to note is that individuals on the registry are supposed to receive their tier designations, and we're supposed to receive it through a letter. If they haven't received that, it may be worthwhile to basically try to get that, or in many cases, just get documentation supporting that they fall in a specific tier. Licensing. Licensing is an absolute nightmare, especially when it comes to any sort of medical licensing. The law stuff is also tricky too. Ideally, you want to avoid the conviction altogether, ideally through diversion or something like that. But in most cases, it's already too late. The general rule when it comes to licenses is that if a conviction is substantially related to the job, details the applicant will perform, that can be grounds for denying a license. And some of them seem rather obvious, like if there's any sort of like elder abuse, clearly an individual probably will not receive a medical license, which you have to take care of elderly individuals. But there are also other things too. You get a misdemeanor domestic violence. A medical board may still see any sort of battery or any sort of act of violence as a potential liability. They don't want medical practitioners around, patients that could potentially suffer as a result. What's also notable, though, is any sort of crime involving moral turpitude, because that could potentially be seen as, an individual might be lying and therefore might be more willing to take drugs from an individual medical setting. Essentially, assume that that any licensing agency will, in most cases, assume that the conviction is directly related. So in most cases, just do try to avoid a conviction. There is a limitation. It's the legislature did notice an issue, so they implemented AB 2138, which says a licensing board may not take away / deny a license if the conviction is 7 years or older and the conviction is not substantially related to the job details the applicant will perform. It sounds great, but in most cases, the licensing agencies will try to create some sort of connection no matter what. When it comes to licenses, expungements, 17Bs and 851.91s, motions to seal arrest-related records, they're supposed to help. They generally have limited effect. Like, it's definitely better than not having a conviction, but in many cases, they'll just see that and think, oh, yeah, this person still has conviction. Instead, what you're going to want to try to do is either obtain a factual finding of innocence or a certificate of detention. Certificate of detention formally reduces the arrest to detention, which is exactly what you want here. A factual finding of innocence is also great because it formally shows that that individual never did anything wrong. My guess is any licensing board will still bring this up. So you're going to want to have the individual provide certified copies of these records, because that'll be their way to either keep or obtain their licenses. Now, something that's a little bit related is concealed carry permits. And these are very, very tricky. It's anytime someone has one of these and they come to you as a criminal defense attorney because they have any sort of issue, there's a very, very high chance that this is simply going away. Under Penal Code Section 2650 and then the related series, basically local law enforcement has almost complete discretion in whether or not someone should have these. And what's tricky about this is you can expunge a conviction. You can, do a 17B. You can seal the arrest. You can get a factual finding of innocence. You can get a certificate of detention, and they may just continue to deny it, and they won't give any reasons why, other than, it's just according to that code, we don't think they met it, and they won't give you any additional details. You can potentially get it reinstated, but it's going to be a very, very long civil battle. Now, one thing that's notable, and especially since we're here in Contra Costa County, is that you may actually get a large number of individuals calling regarding their TWIC cards, and that is the TSA's Transportation Worker Identification Credential Card. And these TWIC cards are basically used to access maritime facilities and vessels, which is notable because say you have people who are working or doing oil stuff, or they're working at the piers, they're transporting things, they have to be put on ships. I got a surprising number of these, which is something I actually never received in Orange County. What's notable about these is there's actually been a bit of a pattern, which is there's been a recent error in which a lot of times these TWIC cards are automatically rejected on the grounds that the individual has conviction without really looking into the conviction. And what's notable is that a lot of the rules that apply to licensing, well, according to that new assembly bill, where it's like, oh, if it's more than 7 years old, you're not supposed to consider it, do apply here as well. And in many cases, they will consider things that are too old, or in some circumstances, will even consider wobblers that are misdemeanors on the record, and they'll just assume they're a felony. They'll deny it, and you'll just have to just walk down the courthouse, get documents showing that, no, this is a misdemeanor, and formally send in an appeal. And then the individual should be able to get their TWIC card, and you'll help them save their job. It's usually a fairly easy process. A common thing you'll find is that in addition to the criminal case, there's also going to be some sort of civil restraining order. So this is either the domestic violence restraining order, also known as a DVRO, and the civil harassment restraining order, also known as the CHRO. They may seem similar, but they actually have very different rules with respect to evidence and standards of proof. For the DVROs, the standard is preponderance of the evidence, and for the CHROs, the standard is clear and convincing evidence. And it's actually, there's a lot of very specific laws and a bunch of things you can actually take advantage of that are basically quite helpful. And for this, I'd actually strongly consider looking at the bench guides. Because there are some very unique rules. Like, for example, for civil harassment restraining orders, but not domestic violence restraining orders, basically any evidence can come in as long as it's relevant. It could be hearsay, it could be double hearsay, it could be quadruple hearsay. It doesn't matter as long as it's relevant. Under Kaiser Foundation Hospitals v. Wilson, this doesn't apply in DVRO hearings. There's a couple laws you probably want to know if you get a client one of these. For their first court appearance, no matter if it's a DVRO or CHRO, they're actually entitled to a continuance to the first hearing if the individual has not filed a response. In many cases, it's not advisable to immediately file a response, not only because it denies the continuance, but also because basically you start running into Fifth Amendment issues. And what do you do about the potential Fifth Amendment issues? Well, there's basically two approaches you can do. The first one is, unfortunately, it's persuasive law. But the case is Pacers Incorporated v. Superior Court. And basically, this is persuasive authority that says that anytime there's a civil action and a related criminal action, in that kind of situation, common practice is to delay or stay the civil action just until the criminal matter has been resolved, so there aren't any deprivations from individuals' Fifth Amendment or related rights. Unfortunately, this is persuasive. I'd say with respect to these, I'd say in about 65% of my cases, the judge will just continue this indefinitely. But in about 30% of cases, the judge sees the docket, sees that, he or she or they don't want it, and they proceed to just say like, oh, we're just going to have a hearing anyway. So in many cases, you may have a hearing, and basically in the event that restraining order is granted, what may be best is to just not have your client testify, so nothing is formally said. In the event that the other side requests attorney's fees, argue that none should be given on the grounds that you identified this issue early, you raised it, and you didn't waste a significant amount of court resources or anything like that. And later on, you just want to file a request to modify or terminate the order. I think it's a CH 700 form, and I think a DV 400 or so form. No, it might be the DV 700. I need to double check that. But in many cases, that may be the best approach, rather than have the client potentially testify and give some very, very problematic testimony, which unfortunately I've seen before. One really, really important thing to note is in the event that you see one of these restraining orders, in many cases, a temporary restraining order will be granted ahead of time. If you see this, there is a specific section on there that says that all firearms must be turned into either a licensed dealer or the police, or basically they have to be getting rid of. And in many cases, I think this has to be done within like 24 to 48 hours, and something has to be filed with the court immediately. In Contra Costa County, there's a lot of leniency, but in other counties, if this is not done, you can expect a search warrant and potential new charges. So you're going to want to make sure your client takes care of this immediately. Oftentimes, by the time the client has reported this, it's already been far past the 24 to 48 hour mark, and you should make sure that they do get rid of the firearms appropriately and that all documents are filed. And also with respect to return of property, in many cases, clients have property that's been seized that's not related to any sort of alleged offense. Basically, the rules vary by jurisdiction agency. A safe thing to do is to get some sort of stipulation or order after the case has been resolved, or in many cases, try to get it before sentencing, just so that everything's lined up. You don't have to have extra court hearings if there's any issues. In some jurisdictions, such as Plumas, you just let the DA's office know. The DA will just be like, yeah, no problem. And your client just picks it up. Not a problem. A big issue, though, is firearms. In the event that any sort of firearms have been confiscated and should be returned, there's an additional requirement, which is that they need to receive basically a law enforcement release. And effective actually December of last year, this has to be done online. This is an extremely annoying process. The approval is only good for 30 days from the day of the letter. And by the time your client receives the letter, there's probably like 14 to 15 days left. It's a good idea to already have an existing stipulation or order so you can immediately take care of this. One thing that's rather annoying in Contra Costa County is in the event that charges are not filed and you cannot go through the criminal court system, you're going to need to file a civil motion for this. That's going to cost you $425 just for the return of firearms that your client should receive. And in many cases, you can just reach some sort of stipulation with the opposing party. Some cases they'll fight you, but I'd say in almost all cases, you should be able to reach some sort of stipulation. And anyway, I believe that should be the end of my presentation as of right now. Thank you so much for sitting through all of this. I hope this has been helpful, and planning to send you a copy of the slides with the hope that this saves you some time in the future or potentially helps you out. Thank you.
Thank you so much, Alan. I wish I could, give a round of applause with everybody. I know I learned several different things from listening to this, and you've just been down the hall the whole time. So I hope that everybody else also learned some new tricks of the trade, if you would, to do this. Like Alan said, he has made this available. Anne will get these out to us, the slides as well as certificates next week. She's on vacation until Monday. So at some point next week, we'll get all of these and the certificates sent out. Just a reminder again, my inbox and phone is always open to talk to anyone if you have any questions, concerns, inquiries, suggestions, etc. And I hope that everybody enjoyed the presentation today.
Yeah, thank you so much for